Good morning.
Your Honors, if I can have a minute just to set up my paperwork and files.
Certainly.
And I'd like to reserve 5 minutes for rebuttal.
5 minutes. Very good.
Okay. May it please the court, I'm Angelo Huang of the Wilson County Bar Association. I represent Robert Cooper and Cooper and Woodall Properties, the appellant. And since you've already read the briefs, I'm not going to bring coals to Newcastle and try to just summarize the brief. I just want to hit the highlights. So there's several issues here. It's the shareholder dispute, not a shareholder dispute, but a oral contract dispute, where Mr. Woodall claims that he acquired a 50% interest in the Cooper and Woodall company and the building that the Cooper and Woodall company owned. It's a place at 162 Jefferson Pike. And they originally met, Mr. Cooper and Mr. Woodall, in 2011. Mr. Woodall had been renting the property from a company called Decade in 2008. And Mr. Cooper was a partner of Decade, and Decade dissolved, so he acquired the Jefferson Pike buildings. There's 2 buildings over Jefferson Pike. He acquired it during the dissolution, and he discussed with Mr. Woodall forming a corporation and contributing the property into it. And the dispute is that the 2 of them agreed that Mr. Woodall could acquire a 50% interest in the company if he paid. Mr. Cooper's position is if Mr. Woodall paid $200,000 within the first year of forming the company and also made the mortgage payments on the bank loan that was on the property of $5,350 a month, then he would acquire his 50% interest in the company. Mr. Woodall's position was that, no, that wasn't the case. Mr. Cooper was to collect $160,000 of money from a second tenant who rented the second building on the property. And once the $160,000 was paid by the second tenant, then Mr. Woodall would acquire his 50% interest in the company. And in the meantime, Mr. Woodall would make the bank mortgage payments of $5,350 a month. So the parties only discussed this in the first year, 2011. After that, there was no further discussions for another 10 years until the property was being listed for sale. And at that point, Mr. Woodall started claiming that he was a 50% shareholder of the company and that he was entitled to 50% of the share proceeds. So we have several issues. We have the enforcement of oral contracts. What are the requirements for that? We have issues involving the statute of frauds, that agreements have to be in writing. And then we also have some issues about estoppel for some of the actions that Mr. Woodall did in treating it like it was a rental property. And I'll explain these in detail. Now, the first case I'm going to cite, it was in my brief.
Now, are you relying both on judicial estoppel and equitable estoppel?
No, actually, judicial estoppel is a little bit more strict.
There doesn't appear to be another court document, so.
Yes.
You're going on equitable estoppel.
Yes. Or something in the nature of unclean hands, or even just Mr. Woodall's intention that his payments were considered rent rather than purchase of shareholder interest.
All right.
On his tax returns, he deducted all of his payments as rent, and a tax return has to be sought under penalties of perjury. So if someone claims on his tax returns that it's rent and gets the benefit of deducting it from his taxes and saving on taxes, then once you pick a lane, you have to drive it.
Now, do you believe the statute of frauds applies if the oral contract pertains to shares of stock as opposed to real estate?
And that is the tricky question, because the cases I cited pretty much say unless something is very, very bizarre, then the statute of frauds applies to real estate to bar any oral agreements. For personality, it's a little bit looser because there's the partial performance exception. And then I can go into that.
And this case, as I view it, pertains to the shareholder interest. The real estate is the byproduct of it, but the oral contract is, I'm going to be a 50% shareholder. Mm-hmm. But but the parties differ on what the terms were.
Yes, and it was hard to unpack the chancellor's decision on that, whether this was considered a 50% ownership of the real estate itself or 50% ownership of the shares. Even though it might seem one and the same, that under the statute of frauds, it changes the exception.
Well, there's no doubt that the corporation owned the real estate.
Yes, it was the sole asset of the corporation.
Okay.
Yes, and I was going to go into that some.
Part of your argument is the contract could not have been performed in 1 year.
Yes.
And on which factual basis are you relying?
Okay. If Mr. Woodall's argument was that he would obtain his 50% interest in the company after Mr. Cooper recouped $160,000 from the second tenant of the building, the second tenant was only paying $2,300 to $2,600 a month. So it would have taken 65 months in order for him to
Much more than a year.
Yes, which is more than a year, yes. So that would have taken him longer to recoup it than 1 year, which would make it fall under the statute of frauds. But also, even without statute of frauds, the ROM Global case stated that to show the burden of proof, to show an agreement to acquire an interest in the LLC and partnership is clear and convincing. And there was a lot of elements that showed at trial that showed that it wasn't clear and convincing. Tax returns, Mr. Woodall considered these as rent payments rather than shareholder purchase payments towards the shareholder interest. Mr. Woodall asked Mr. Cooper to draw up and backdate a lease agreement for him, showing that he was renting the property so that he could get government COVID loans. So there's actions that he took that contradicts his belief that he was a shareholder. Those are things.
Why does the clear and convincing evidence standard apply in this case? What is it about this transaction that makes it applicable?
It's hard to say. I'm not quite versed on the history of it, but it seems if you're claiming a partnership interest, then that somehow has a higher burden than just a normal contract. Maybe it's because it vests into a separate entity, your interest. So I can't really speak as to the reasons why it's different in terms of a corporation or LLC.
So you're saying, oh,
Go ahead. No.
well, so you're saying anytime someone is interested in acquiring a share interest in a corporation and the agreement's oral, it's always clear and convincing standard then?
That's what the ROM Global case.
Now, that one case indirectly says that, but aren't there several other cases that say it's a preponderance of the evidence?
I did a Lexis search to see if there's a different standard that applied to corporations, but unfortunately, maybe I'm not good enough at Westlaw searches, but the ROM Global case was the one I found that was a positive to me. And it deals with LLCs and partnerships, which isn't the same as a corporation, but since they're entities and since they involve ownership of business, then I would say it's analogous to what a corporation would be in terms of standard. And so we have the issue of part performance being an exception to the statute of frauds when it deals with personality. And in this case, if the chancellor decided that this is an action for shareholder stock rather than an ownership of real estate, then there is partial performance, but it should be used sparingly. Because pretty much every oral argument or oral agreement that involves a contract will probably have part performance by one party or both parties. So to allow partial performance would lower the bar where anyone that just did a minimum amount of performance could claim the exception to the statute of frauds. So that's why we probably should be more careful about not letting the exception swallow the rule of the statute of frauds.
Mr. Woodall here provided a guarantee
Yes.
of the loan that was assumed in the original transaction. How did that fit into the overall structure of the transaction?
The guarantee was in anticipation of Mr. Woodall becoming a shareholder. This was before the corporation was formed, because at the beginning, both of them had the idea that we would form a corporation together, you would be 50% shareholder, but the problem was what the terms of that were to be. Mr. Cooper said, pay me $200,000 within the first year and make the mortgage payments. Mr. Woodall says, no, it's Mr. Cooper is to recoup $160,000 of money from the second occupant of the building on the property.
So
then
you would
have-
say, at least in that respect, there was partial performance because Mr. Woodall did in fact give a personal guarantee.
Yes, yes. But that's under, so there's a condition precedent to this oral agreement that he would also make the $200,000 payment to Mr. Cooper too. So,
Well, he wasn't making the payment, the tenant of the other building
Well-
was making the rent payment.
yes, yes. Well, and that's where the disagreement comes from. What were the terms of what Mr. Woodall was supposed to pay in order to get his 50% interest? Was it
Mr.
200?
Woodall was paying a rent in the amount equal to the monthly mortgage payment, is that right?
When he had the property with Decade, and I'm out of time,
Please,
but I can maybe pick it up on rebuttal.
No, please finish, please answer the question.
In 2008, Mr. Woodall was paying $3,000 a month rent to Decade, the prior owner of the property. And then after meeting Mr. Cooper, they discussed forming the company and him getting 50% shareholder interest if Mr. Cooper was paid $200,000 in the first year. And also part of that was that he would make the payment to the mortgage company of $5,350.
And Mr. Woodall was to pay that $200,000. Is that
To
correct?
Mr. Cooper,
To
yes.
Mr. Cooper.
So it was a one-time,
And in Cooper's view, that wasn't the arrangement. Cooper thought he was supposed to get $160,000 from, no, Woodall
No,
thought
yes,
Cooper
it's
was
reversed.
supposed to
Yes,
get
yes, yes.
$160,000
Mr. Cooper wanted-
from the rent from the other part of the building.
yes, Mr. Cooper wanted pretty much a lump sum payment in order for him to purchase shareholder interest, while Mr. Woodall's position was that, no, there was no upfront payment. Mr. Cooper would just collect $160,000 from the second tenant, and once that's done, I would get my 50% shareholder interest, as long as I kept up the loan payments. So,
All right.
so that's the distinction.
Thank you, sir. We'll hear from you again on rebuttal. Mr. Jenkins?
Good morning, may it please the court. Josh Jenkins from the Rutherford County Bar on behalf of Mr. Woodall. I think that the court has kind of zeroed in on the crux of the issue here, and it is our position that part performance, nearly full performance was performed here, which would take it out of the purview of the statute of frauds. Statute of frauds, as the court said, I don't believe applies in this situation. Real estate is kind of the secondary issue to actually acquiring the membership interest. And so it is undisputed that the parties discussed prior to the formation of the company and prior to the purchase that they were going to be 50% members of this LLC that was formed. And reliance upon that,
It was a corporation, wasn't it, not an LLC?
it was an LLC.
It was,
Well,
okay.
but it says Inc., doesn't it? The name of it, Inc.?
Oh, I apologize. It is an Inc. I'm sorry, a corporation. And so at the beginning, there were these discussions that they were going to each own 50% interest in this property that they were going to purchase, that Mr. Woodall had been occupying for some time running the sheet metal business.
Well, so I would expect the price for the shareholder interest would be an essential term of this contract. Would you not agree?
I think that I think that they did discuss that. I think that when you look at.
But, well, let's start with the primary. Is it an essential term of this agreement?
Yeah, there has to be some value assigned to
So
whatever you're doing.
They have to be a meeting of minds of what that price is going to be.
Correct.
And the court has heard testimony from both parties, and they're not in agreement on the price.
Well, respectfully, I think that Mr. Cooper said what he needed to say at trial to try to thwart what the actual agreement was. Because if you track the actual paperwork all the way through what Mr. Woodall's testimony was, it's clear that the discussion was, it was the $160,000 because that was the equity that was brought to the table by Mr. Cooper in the property. And so there was clearly thought out about what was supposed to happen. So Mr. Woodall is going to pay the mortgage on his own for the suite that he occupied in his sheet metal business, while Mr. Cooper retained the rent from the other suite from that tenant until that $160,000 was recouped. And so that was the plan. That's why there was never discussions after the fact.
And so other than the conflicting testimony of the parties, where do I look for proof? You say if I follow the documents, I can see where it was 160. What document do I look at to say, oh, okay, I can see here where the parties reached an agreement for 160?
So at the time that the property was purchased, they had this discussion about how this is going to go down and what the membership or the interest in the corporation was going to be. The corporation was formed using the names of the two people that are going to be the 50% owners, which normally if I'm forming a corporation, that I'm not going to add somebody's name to it that is not going to be a member, or I'm going to use some other name. The appraisal that was submitted at the trial included Mr. Woodall as borrower/purchaser, owner, or something like that in the terms. If you look at the actual closing documents, it was undenied and stipulated to at trial that Mr. Woodall participated and attended the closing. He was the one that actually facilitated bringing the loan to the table. And the testimony at trial was Mr. Woodall was an intricate part of this deal because it had to be at least 50% owner occupied to get this loan. Otherwise, it doesn't work. So that Mr. Woodall was going to still occupy 50%, one of those suites.
Okay, so all that establishes the amount of shares that Mr. Woodall was going to acquire, or at least the nature, the percentage of the interest he was going to acquire. But what do I look to establish the 160?
That was, at testimony, that was the equity that Mr. Woodall.
So we only have Mr. Woodall's testimony on that point.
What we also submitted and went through the settlement statement at trial based on what the loan amount was at closing and what the value of the property was, what he got from Decade to buy it out. And we had to go through the chalkboard and run through all these numbers. I know it's probably not as clear from the record as we would like it to be, but it was clear that the parties knew what this number was.
So Mr. Cooper's contribution to Decade Properties for acquisition of this real property was 160 or 100?
It was the equity of the property that he was bringing, which equated to what they discussed and what Mr. Woodall testified was about $160,000. That was the number that they agreed on.
I see. So, and that was based on the overall valuation of the property?
Yes, from the appraisal versus what the loan is, because they were basically paying off, if my recollection's correctly, once Mr. Cooper got the property from Decade, which he was a member of, he was kind of buying this out. And so the property was worth more than the loan necessary to purchase the property, and that's how they figured out. The property appraised for I think it was 800-something thousand-ish, and the loan was only 640. So that's how they came up with about the 100.
Where does the 200,000 come from? Or
I don't know. That was what.
but how does it? I thought I understood the two until oral arguments, and I'm now confused. There's a $160,000 equity payment, but then there's a $200,000. But that comes from the other tenant's rent. Is that correct?
Well, so. Mr. Cooper's position was it wasn't going to be the 160 that I'm keeping from the rent. It was supposed to be $200,000 paid within a year, okay. which that in and of itself would anticipate and take it out of the statute of frauds anyway. But given their argument, because it's supposed to be paid in less than a year, or could be paid.
Paid by Mr. Wagner.
I'm sorry?
Paid by Mr. Woodall.
That was their position.
Yeah.
So there aren't two separate funds. There's one, but the question is it 160 or is it 200?
And how was that supposed to be paid?
Thank
That was really.
Thank you.
That was in essence the conflicting testimony.
There was no source for the 200,000 except from Mr. Woodall.
Just pay it.
But there was a source for the 160, and that was the rent from the second building.
Correct. And I think if you look at the transaction, it does make sense because at trial, the testimony and the documents showed that the rent money from that other suite, Mr. Cooper kept that money or used it to pay. There was never any allocation or anything like that of the shareholders.
So was your client paying directly to the bank the mortgage payment?
Well, that's my next point, is he was also a 50% owner of the corporate bank account. And so what he would do is he would actually put that money into the bank account to pay that mortgage. And then I cannot recall, as I said here, who made that transfer. It might have been Mr. Cooper, but that money was put into the corporate bank account, which Mr. Woodall was a 50% owner of, a signer on.
And
pay that
what
mortgage.
was the, oh, sorry, go ahead.
His rent was paid into the corporate bank account, but then another check was written by the corporation to the bank.
I can't recall if it was an auto debit or if it was a check, but yes, that's
Some-
how it would track.
But, okay, thank you.
Yeah. And then what was the term of the loan?
It was, I honestly, I do not recall what the term of the loan was.
Was it more than a year?
More than a year? Yeah, oh, yes, Your Honor, it was. It was.
So if part of the agreement, as you understand it, is he was to continue to make his rent payments as part of this transaction, acquire the interest, how could that be performed within a year?
It couldn't, but I would submit that the part performance takes it out of the purview of the statute of frauds, because there was no objection to this arrangement and how this was going until, unfortunately, Mr. Cooper began to go through a divorce, and then it came up that, oh, this property's now got to be sold because they were treating it as a marital asset. That's what ignited this fire between the two individuals, because all of a sudden a real estate agent shows up to kick Mr. Woodall out of the property. And so that's what kind of began this whole scenario.
It sounds like, and I know this is going to be a bit tough, but to be fair, my reading of the record, it sounds like all of this confusion was based upon the fact that each man was trying to defraud his soon-to-be ex-wife.
There was some testimony about, I think that might have, I can't remember what the testimony was about.
They were trying to hide the assets with a pending divorce.
Correct. I mean, I think there was some.
And
Now,
now-
ultimately, that divorce didn't go through for Mr. Woodall, but that's what tipped the scales in this scenario was with Mr. Cooper, and the court in that scenario ordered that the property be sold and we're treating it as a marital asset. And
Now,
so
in a nutshell, what facts do you rely upon to satisfy the partial performance criteria? What facts?
I think you look at the very beginning with actually participating in, obligating himself, including Mr. Cooper, including Mr. Woodall's name.
Guaranteeing the note.
Guaranteeing the note, all of that. He was also listed as an owner of the bank account. And then from closing up until the divorce, that's the arrangement that both parties abided by. My client paid the mortgage. There were some missed payments in there, and there were some credits given during COVID and everything like that. And Mr. Cooper received solely the rent from the other building. There was even testimony at trial that my client paid some of the property taxes. He paid some for repairs to the building that he was in, and he got some credits for those as well. And so there was always performance. Upon the terms that Mr. Woodall was testifying were the terms until the divorce came up and the property needed to be sold. Then it changed. That was kind of the very first time that this 200 number paid within a year came out. There's no document or anything like that, and I felt like that Chancellor Smith, after hearing the testimony and looking at it, he mentioned then that, hey, I'm a court of equity. I think that this ruling is needed to avoid an inequitable result, because given the testimony, I think that this is what the agreement was.
How did your client treat his interest in the corporation and his tax returns?
So the testimony was that on his Schedule Cs, I think, which is maybe I think that might be a business, that the mortgage payments were treated as rent. And he was paying that, obviously, to the corporation. Now, I'm not an accountant, and I don't do taxes. I know Mr. Wong does do some of the tax stuff. If an accountant told him that you can do that and save money on taxes, I mean, I know, that you might, law firms might own a building, or that partners might own a building that's a separate entity, and then the law firm, which they're a member of, pays rent to the building. I don't know. I can't really answer in any detail to that. I just know that.
And there was no documentation whatsoever. I mean, was there even a charter for this corporation?
I believe there were some corporate formation documents that Mr. Cooper had drafted by some attorney.
Okay, and did they come into evidence?
I don't recall that they did.
So no charter, no subscription agreement, nothing came into evidence.
No, I think it at least very much began by these gentlemen knew each other at least some way, because Decade was the owner, and it was kind of an evolving friend type deal because Mr. Cooper was getting out-of-decade properties. And so, you know, Mr. Woodall, I get to stay here and I get to be a part owner of the building, and they just kind of ran with it. And Mr. Woodall, the testimony was the one that kind of brought the loan option and that contact, and he was going to be, again, like I said, he was going to be one of the reasons that loan, that mortgage even worked, because he had to be an owner, which is why he was listed as an owner on the appraisal that the bank ordered, which is why he had to sign a personal guarantee, which is why he was at closing, which is why his name was even included in the name of the corporation.
Assuming for the sake of argument that the settlement statement for the closing of the property transaction from Decade Property to Cooper and Woodall establishes the 160, what document do we look to that establishes the payment term here? How long your client had to pay, or how Woodall recouped the 160 over a year?
I don't know that there is a written document other than whatever the tenant's rent was in the other building, I would assume including any increases, went strictly to Mr. Cooper to satisfy up until that 160 was.
Is that lease in the record?
I don't believe it is. I don't believe it is.
And we know that your client's original contract with Decade, this lease purchase agreement, only the first page at best is in the record.
And if I know I'm almost out of time, but yeah, that is correct. It wasn't a complete lease
So we don't even know what the purchase option was, the terms of it.
at that time. I don't think there was any testimony that he attempted to exercise it at the time this whole thing came about. It was just that there was one.
So how do we enforce an oral contract if we don't know all of the material terms of the contract?
Well, there has to, you have to have mutual assent to the terms of the agreement, and I don't think that,
Yeah, the key words there are the terms of the agreement.
and I think that you have the essential terms of what the agreement is. So there, and there is some case law, albeit with an LLC membership interest. I don't recall off the top of my head if it also applies to a corporate membership interest, but there also is some case law out there, because I have a case going in Rutherford County right now, that failure to pay a capital contribution or something like that does not necessarily mean you're not a member of that company. You might be in breach, and there may be some other ramifications to that, but there is case law out there that specifically states that the failure to pay that in, if the parties have agreed that they're members, that failure alone does not mean you're no longer a member.
What is the burden of proof, the standard, clear and convincing, or preponderance of the evidence?
I believe that this is a preponderance of the evidence. I think that, Your Honor, when you asked Mr. Wong about the ROM Global case, it is a singular case out there about it, and it doesn't even go into really the details or nuances of is it different or is it similar. It just kind of says, well, we don't see anything that says it couldn't apply to an LLC, but it doesn't specifically talk about a corporation. And in that context, it was two companies forming a partnership, which is, in my opinion, a little bit different than two people forming a corporation. Because if you want to do a partnership, and even if you get down into that, partnerships can be implied whether you mean to form a partnership or not. That's the business law, and I think that we have enough facts here even to get to that point.
All right, thank you very much.
Thank you.
Mr. Wong, your rebuttal.
Few points. Although Mr. Woodall shopped for a loan at the beginning, the actual loan was procured by Mr. Cooper through a different agent. So Mr. Woodall only did preliminary shopping for a loan. He claims that the loan was supposed to be owner-occupied, but the actual loan document is a different loan that doesn't have the owner-occupied requirement.
But he did guarantee the loan. And,
Yes, he did.
And both
Yes.
of the gentlemen represented that he was a 50% owner of the entity.
Or would be. I don't know if they represented at that time that he was.
Well, didn't the bank require that the guarantor be a 50% owner?
Oh, they're talking about owner-occupied. That's where you loan property if you're going to occupy the property. But that doesn't involve shareholder interest. It just means that you're occupying the property I don't know.
But it says owner.
True.
Who owned
Yeah.
who owned the property?
But anyone can
The,
really be
the
a guarantor.
corporation owned the property.
But anyone can be a guarantor. I mean, my nephew can be a guarantor for my loan, my aunt, I mean,
Well, somebody represented to the bank that Mr. Woodall was an owner.
I don't know if that was testified to by anyone at the trial.
I think it
Even
was.
though it might have been, I don't know if it was being presented at the trial anywhere.
Well, it says owner occupied, doesn't it?
Not the actual loan.
Well, the
No.
actual loan?
Actual loan itself, no. Mr. Woodall applied for an owner-occupied loan at first, but Mr. Cooper obtained a different loan. So the one that Mr. Woodall was shopping for wasn't the loan that actually was gotten, that was issued.
So you're saying the loan that was procured does not require owner occupied?
No,
All
that's
right,
not
thank you,
required. Yeah.
thank you.
The one Mr. Woodall was shopping for originally was, but not the one that was actually issued. It's two different loan applications. And the chancellor was confused by the HUD. When you read the transcript, I guess maybe the numbers were overwhelming or something, but I said the HUD was very confusing. And supposedly, it was claimed that both parties were hiding the assets from their wives. Mr. Cooper wasn't hiding anything from his wife. In 2011, he was married, he was happy, there was no divorce pending. In 2021, there was a divorce pending, but not that. It was Mr. Woodall who was going through a divorce in 2011, that he didn't want his name showing on the corporate records. And the corporate records and minutes and charter are on Exhibit 13 of the trial exhibits, so they are entered into the record, just to clarify that. And the thing about partial performance, so even if you do partially perform, it's the conditions and the terms that are important. Pretend I agreed to sell you Amazon stock for $100, but you only paid me $50. But you said, that's complete, I partially performed. No, it's the purchase price is key. That's the big conflict. Is it supposed to be $200,000 within 1 year, or is it supposed to be Mr. Cooper recoups $160,000 from the rent from the second tenant of the other building within X number of years, 6 or 8? So payment plan or lump sum, that's a big difference.
Was there ever a lease entered into between the corporation and Mr. Woodall after he failed to make the payment that your client suggested he make within a year?
A lease?
A lease.
No, they,
Because it became a lease, I mean, under your position, it
Yeah,
became
yeah,
a leasehold interest.
Pretty much
After a
did.
year,
Yep.
he just threw up his hands and said, we're going month to month
Now,
on
the
this.
gentleman got along great back then. So I think it was just spit and handshake, month to month. You just continue as you continue on. So there was no lease drawn up after that. Or there was no discussion at all about the shareholder interest thing for 10 years. They discussed it in 2010, or 2011, 2012, and then after that, they quit talking about it anymore, and then it came up in 2021 when the property was being sold.
Yeah.
Also, the thing about the capital contribution, Mr. Jenkins gave the example, like if someone didn't make a capital contribution to a partnership, then the only recourse would be a breach of contract. It wouldn't be denial of their shares, which is true, but that's after you become an owner. There's preliminary steps before you can become a shareholder. Once you're in, you're in. So once you're a member of the club, you're in the club. But to be a member of the club, you have to jump through the hurdles, and that is to make the $200,000 payment to Mr. Cooper within a year. And and just one more point.
And the $200,000 payment from your client's perspective was to be a payment from Mr. Woodall, not the rent from the
No,
other?
it was supposed to be cash out of his own pocket.
Okay.
And Chancellor Smith said that it's foolish for Mr. Cooper to have sold an $800,000 building at half interest for only $200,000. But Mr. Woodall's situation is even worse than that, because for Mr. Cooper to recoup the $160,000, Mr. Woodall isn't contributing anything. The $160,000 is coming from a second tenant. So his only marginal increment is the $2,000 extra month
No,
mortgage payment.
I mean, Mr. Woodall is contributing something. He's giving a credit enhancement for a loan. I mean, when you put your personal credit on the line, that is something, that's consideration. That is certainly more than a barleycorn.
Okay, well, in terms of the dollar amount that supposedly was going to be exchanged, so it's agreed that he signed his guarantor, which wouldn't activate unless the loan was in default. So he did put himself at risk there, but the property had equity in it, so if it foreclosed, then really he wouldn't be at risk because it has equity to cover it
All right.
flows.
Thank you
Thank
very
you,
much.
Your Honor.
Thank you both for your arguments. We'll take this matter under advisement. Call the next case, please.
Carla M. Reichert versus David K. Reichert.